Namaskar to all the participants, including my fellow panelists, speakers, and others not present here today. I say Namaskar, but particularly for a reason. And when I ask at various, not here, but I will not, or I may, at a number of places, ki please explain me the meaning of Namaskar. The answer I get is good evening, good morning, equivalent. I said, no, there is much more to it in Namaskar. And that much more to it is the person's salute to the divine in the other. Each of you has a divine in yourself. And when I say Namaskar, it is through that divine in you I speak to the Almighty above. That is Namaskar. The topic, rather the subject I will say, revisiting the Constitution, is a wide one, very wide one. It will need many more minds, many more thoughts, research, study, empirical study, ground level study, and now, quite similar to the name of the organizers whom I thank, data analytics of what the society requires. It is that we will be able to achieve a result of improving our constitution. Already, Shantaji has said about the living nature of it. Other speakers will address. I will focus on only one point, and just one. I don't want to distribute it around to too wide an area. And that is the privilege against self-incrimination, which is enshrined in Article 20, Clause 3 of the Constitution. I have noted it here, Article 20. That is, no person accused of any offense shall be compelled to be a witness against himself. This has a background, and the background or a history lay in the torture at the Star Chambers in the 17th century in England. To reminisce those horrors, the America, when they made their constitution, they had a Fifth Amendment, right to silence. In Britain, it is not in the constitution, it is part of their law otherwise. Other countries, other legal systems also adopted it. This I am talking before 1948, that is when the thought process of the Constituent Assembly to frame the Constitution began. In that day, in that scenario, there was crime. Yes, it was. But what was the type of crime then, and what is the type of crime today, 73 years later? Either you have a quick look at your own experience, or you can open the criminal law reports of 1949-50 and compare them with the criminal law reports of 2022. Complete sea change. Yet, Clause 3 of Article 20 has not changed. It has not changed to allow to fit the crime. Second, when a crime occurred in 1949, what was the evidence generated? That is what required analytics. As I said, I'm using their name a little too often. Analytics at my end. Okay, what was the evidence then? Analyze. Of course, those who were lawyers and judges of that era are no longer there, but the law reports stand still in the library shelves. 98% of the evidence in a criminal prosecution was oral witnesses. हमने देखा था, cross-examined. Believed, not believed, that's a different system. But that was 98% of the evidence then. The remaining 2% was either forensic, sometimes called real evidence also, forensic comes later, part of it, or it was some documents or records which were very few. Fast forward 73 years. What is the evidence today? First in quantity and second in proportion. If in quantity, oral evidence, and when I say quantity, I don't mean just the number of witnesses. I also mean or include the authenticity of those witnesses or credibility of those witnesses. The number has remained the same. People are not willing to come forward and give evidence for various reasons I need not go into. And those who come and give forward are less credible today than they were then. But then, second, apart from oral witnesses, the real evidence from which forensics develop, trace evidence, etc., that has changed, substantially increased. Substantially, twice, maybe 5 times. Documents and records, which were hardly there in 1948-49, are there for every little thing we do or omit to do today. And it's interlocking records and documents. As a multiplier, I will call it a few hundred times. And finally, in the last 5 years, or let me say last 3 years specifically, we have digital evidence of crime. And that has multiplied as evidence, quantity and quality. Of course, few instances of fake are also there. But quantity is thousands of times. So that is the evidence today, which is generated by a crime. And yet, despite increase in crime, despite fear in society, despite change in type of crime, despite a complete sea change in what is the evidence that generates of the crime, it's automatic generation. I'll explain it a little later further once I've made my point. Our Article 20, Clause 3 continues as this. The Constitution requires revisiting on number of issues, and my learned other speakers will enlighten us on that today. But I asked myself, when it comes to Article 20, Clause 3, today, a court cannot ask the accused, let me put it, I don't expect the court to ask, though every court says, do you plead guilty? And without even hearing the answer, the court is, plead not guilty, it claims trial. That is a practice. But where is the questioning by the court of the accused? Not. Where? No provision. Why? It's Clause 3. Second, there is a difference between an incriminating evidence and a non-incriminating evidence. Point put forward is, I'll just take a small sample here. I'm sure the participants and attendees today would have had occasion to go to a supermarket and buy a nice knife for use in their kitchen to make a tasty meal. Especially the ladies must have had that occasion. Now, so long as that knife is used, so long as the purchase of that knife by a person at a particular time, maybe payment by a credit card or even now all this cell phone through payments. It is evidence. Evidence of what? Just a mere purchase, nothing else. But if a crime occurs and that knife is used for that crime, the clause 3 says, you can't ask the accused, is it your knife? Did you purchase it? That purchase, where is it? How did you pay for it? That is prohibited by clause 3. Point is, there are so much evidence today that generates, so much, which is not incriminating. But if there is a crime, it becomes incriminating because it is the best proof of the crime. Let me take a sample here. At 4:30 p.m. in the Central Market, there is a murder. And the suspect or the accused had texted somebody at 4 o'clock that please wait in the car, keep sufficient fuel. I will see you at this point and keep the car ready. I have to just go for a meeting somewhere else early. Nothing more. Accused is caught. He is arrested on the spot. And then can the court ask him, please produce the text message to so-and-so. Police find it, they place it before the court is a separate matter. Can't. Or can the court say, on the 10th of December 2022, between 16:15 to 16:45, what were your whereabouts or location? Just give us that. Now, simply saying, I was at the Central Market is not incriminating. He could be purchasing a nice ice cream in the Central Market. But it becomes incriminating only because he is suspected of murder, and this particular or other pieces of evidence, including his cell phone pinging on the tower there, are first-class proof of his involvement. His cell phone, which he is carrying, may be password protected. Only he knows the password. What is contained inside is evidence of crime. It could be a murder, it could be a financial crime, it could be a scam, it could be anything. Can our courts direct that enter your password and decrypt? Or we have to send to the foreign company who made the telephone to open the locks? Or some of our boys and girls have now excelled. And I'm happy to inform you that many of these boys and girls have been recruited by our police to be able to open those telephones which they seize from the accused or suspects. But coming back to the larger topic of today, revisiting the Constitution, does Clause 3, as I take you along, not require a fresh look? What is that fresh look? Is a matter of debate. But the debate has to begin. And I seek to begin that debate today, thanks to the organizers for giving me this opportunity. But I leave it to you to carry forward. I'll carry it forward. I carry it forward. I do not say that you abolish Clause 3 altogether, delete. No. We can't go back to the Star Chamber days. Though, frankly speaking, as part of my research, having interviewed hundreds of police officers serving and retired, till about 10 years back, there was too much element in our country of torture and third degree. How the evidence is received, who is put forward, these are separate issues of detail. That has reduced, and in fact, it must be eliminated. There is also a component of false confession. That has also to be prevented. And that will be, both these require a Clause 3, but in a new form. Today, you see this derivative from a school seesaw where all of us had the privilege of playing when we were few years old. I was no exception. Which is weightier today? The rights of the factually guilty or the rights of the society? I have drawn it, but it's for you as part of starting the debate to see if I'm in error, it is in level, horizontal, or the balance or equilibrium, as we say in the economics terms. It's different, but it is not. And I'll explain it. Privilege against self-incrimination is related to is a part of human rights, no difficulty, but related to two other principles. One is presumption of innocence, and the other is a presumption of innocence, I would place it, and the other is, well, the human right of the accused for a fair trial. But what is a fair trial? A fair trial is that gives full opportunity to consider the innocence or otherwise. A fair trial is not which gives every right to an accused to obstruct and delay and seek an acquittal. That is not a fair trial. It may be fair trial from his eyes, but from the society's eyes, it is not. Because greater the crime, the lower the economic growth of the nation. It is freedom from crime which then enables the various engineers, agriculturists, commercial people, their mind to work and grow. Economy grows, economic activity occurs, but not when you live in fear of crime. That is the unfortunate part we have been seeing in increasing numbers. I take one crime. Let's take a crime all of us have heard of, scams. How many lakh crores we have lost, never to be retrieved, to scams in the last 30 years. And if 30 years back, the scamsters had not been allowed this privilege to keep quiet, refused to answer. How much of that money would have recovered and how much of future scams till today would have been prevented? Today, Clause 3 prohibits a court from asking, please give a list of all bank accounts you operated in that 5 years preceding the filing of the FIR. That's why I'm using word next preceding filing of the FIR, not subsequently. Where is that? Where are those bank accounts? So he simply says, चुप रहना मेरा कर्तव्य है, पूछना आपका अधिकार नहीं है. हाँ, अपने आप ढूंढिए, जाइए सारे बैंकों में पता करो मेरे कहाँ अकाउंट है, किस नाम से है, नकली है, असली है, मैं नहीं बोलूंगा कुछ भी. If all that scam money would have been how many people lose? And people lose their savings is one thing. This privilege, part of human rights. I ask, the children who go to school, they have a human right to education or no? Nobody, they do. They have a right to 3 chapatis for their midday meal. That is paid for by the Consolidated Fund of India, Article 266, from what are the general taxes. But if 100 rupees leave for education and the children are deprived of 80 out of those 100 and only 20 reach, or if say, well, I'll not say 3, I'll say 3 lakh chapatis leave the central fund as value, as notional value, and only 50,000 reach, and somebody eats them away to build a palatial house. And then he says, no, you can't ask me how I did this or what happened or what records are this. That is where the privilege needs a rethink. So it is deprivation of social goods and services and opportunities, as I put at the bottom of this pie, which is a very integral part of our human rights. Unfortunately, there are today, because of what has happened in the last 73 years, the intellectuals, like I see sitting in front of me, they are not bhoka pet. They are not shivering at night for want of a blanket. So they are a little loath. I'll only use the word loath. Generally, but fortunately I see an interested audience before me today who also think of what is the bhook of others, or the sardi, or the child walking barefoot in winter. Well, some children are lucky to have designer shoes. All right, 10,000 rupees designer shoes, 18% GST, fine. But the basic chappal, that needs a subsidy and it needs availability, even if it is 50 rupees. And it must reach. It must not have a siphoning out on the way, so as to enable somebody, and that somebody is enabled. That somebody is enabled because our Clause 3 of Article 20 allows him to keep quiet. You look at it from an attempt to strike a balance. I don't say that don't give a fair trial. But what is fair? Fair is where the rights, I'll put it in 2 parts, where the rights of the society on one side, or the social defense, and the accused on the other are balanced. Second, fair means where your laws and procedures, uninhibited by Clause 3, enable minimal minimal acquittal of the guilty and next to no conviction of the innocent. That is the purpose, and do so in a reasonable time. Because the criminal justice system, let me tell you friends, now this is the economics principle which I am drawing into law here, operates on externalities. We have all seen how the light of a lighthouse is made available from the 17th century onwards to all the ships. Now, of course, it's GPS navigation. But that light was emanating from one lighthouse, and it was available as an externality to all the ships many knots away. Today, the criminal justice system is exuding externalities. Now, what are those externalities today? Positive or negative? Positive would be a clear message. Clear message. If you commit a crime, the probability of your getting caught is high and your acquittal is as good as is low. That is the positive externality. And a negative externality, as our system today exudes, is that, all right, you commit a crime is beneficial, and the cost-benefit ratio of crime will operate to your benefit. There is not more than 25% probability of your being convicted, maybe even less. So, go ahead, commit crime. Fortunately, as I have studied, in India, our morals which we have inherited from the Vedic times are the ones which are holding us together in our DNA from Vedic times. And it is not the criminal justice system which is actually encouraging by its negative externalities. That's why it needs a rethink, it needs a redesign. Very many people to say, all right, to lead an honest, hard-working life is no good, let us take to crime. If that is the message sent out. Here I am referring to criminal justice system generally. Number of issues are required to be addressed, but a major issue is privilege against self-incrimination as contained in clause 3 of Article 20. I do not know whether many of you have been practicing law on the criminal side or no. Yes, then I'll give you that illustration, which I would not otherwise. Let's take a typical criminal case. What are the exhibits in that criminal case? 50 exhibits. Now, those 50 exhibits, let me tell you, friends, according to my research, the probability of a fake is below 1%. But the remaining 49 exhibits denied. Prosecution must prove. At what expense? At what? Mera driving license? Prosecution must prove. Mere ghar ka pata? Prosecution must prove. I would not be surprised to an accused to say कि मेरे बाप का नाम, prosecution must prove. I mean, what is obvious? What is straight? What is plain? And in today's date, kindly what I just said about 15 minutes back, for everything, evidence is being generated automatically. All that is to be allowed by a change in Article Clause 3, allowed to the court to ask. And if the answer is still silent, then I say reduce the strength of the presumption of innocence. And if the answer is a lie, today Section 313, CRPC says you can't be prosecuted, but why not if it's a lie? And that is why I'm always reminded, and not me, any debate on the subject is reminded of Jeremy Bentham's word that if all the wrong persons got together to make the law, is this not the first law they'll make for their own protection? That is what Jeremy Bentham said, and more. Because the utility. For those who are interested in further research on the subject, just pose a constant question to yourself. If, for what is plain and obvious, admission could be sought from the accused, and based on that, the trial proceeds, where will our criminal justice system be? Unfair or more fair? And where will it be the balance? So with that, I would say thank you to the organizers and thank you to the attendees to listening to me and giving me an opportunity to express my thoughts. And I make an appeal, please work further. This will make the Bharat that अपने सपनों का भारत and a crime-free Bharat. Jai Hind.